All right, is notice required before towing an illegally parked car in the Ninth Circuit? All right, my guys, my friends, my name is Anthony Bandiero, attorney and senior legal instructor at Blue to Gold Law Enforcement Training. Bringing you to the roadside chat. This one comes from an officer in California. So the officer says, "Hey, look, so my department recently learned about a Ninth Circuit case called Grimm versus the City of Portland that requires law enforcement to notify vehicle owners before their vehicles are towed. In this particular case, Portland PD gave this guy like 6 or 7 tickets over a week period, put big orange stickers on his car, tow, like, move it or it's going to be towed. They eventually did tow it. The owner of the car, who happened to be a lawyer, didn't want to pay his parking fines, I guess, sued the city of Portland, alleging a due process violation because he was not individually notified, right? I mean, the car had the stickers on it, but he was not notified individually. Ultimately, the Ninth Circuit agreed with Grimm and found that this violated his due process absent some immediate public safety need to tow the vehicle from the roadway, something else going on. And he says this has stopped all of our tows for vehicles past 72 hours, which violates California vehicle code. So what the ultimate question is like, all right, is this, well, it's required, but, he knows it's required, but I was putting out to you because a lot of people don't know this. In fact, I didn't know this. When he sent this, I did not know about Grimm. So I'm going to put the citation and some description information in the description, but let's go through this, right? So I've never seen this before in another circuit. Maybe it exists out there. Again, it exists in the ninth, and I was not aware of it. The case is from 2020, so it's not too old. But this does not change how cops in the Ninth Circuit handle vehicles that are, again, blocking the roadway, blocking people's driveway, in front of a fire hydrant, some other compelling need to get the car, towed, right? Of course, it does not affect at all probable cause searches, right? If you want to tow the vehicle or for a warrant, if you want to tow the vehicle back to your station and search the car there, and so forth, go for it. This does not have anything to do with it. What this case is really about is that situation where the person is illegally parked and that's it, right? Because they're not moving it, or I would think that they have not paid their meter, right? And they leave the car there. In this case, it seems that they want the Ninth Circuit wants individualized notice. Now, ultimately, that's what the officer's question is. So let me read a kind of a quote from the case. So, the Ninth Circuit says we have recognized a few exceptions to pre-towing notice requirement. So, for example, no notice is required, pre-notice, when the car is parked in the path of traffic, blocking a driveway, obstructing a fire lane, appears abandoned. Take note, appears abandoned, right? Constitutionally abandoned, not just not returning to the car after 72 hours. Or, check this one out, has no current registration stickers, and police can't be sure that the owner won't move and hide the vehicle rather than pay the fine for illegal parking. However, if there is reason to believe, or if you have reason to know who the owner is, you're going to have to do pre-tow notification, individualized. So, actually, in Grimm, by the way, even though it showed expired, it actually was current. The Grimm did not put the sticker on, so that actually works against the city of Portland. So when they ran the car, it did show current. So we're not going to. So the Ninth Circuit did not treat this car as an unregistered vehicle. So here's what I think. I think really we're looking for two things. One is, if you're going to tow this car for simply being illegally parked, I think you're going to have to send out a certified letter to the registered owner, the address on file, let him know that his car is illegally parked, where it's at, and how much time he has to go pick it up. Whether that's 3 days or whatever it is, right? Or you knock on his door and he answers and you tell him his car's legally parked. That is individualized notice, right? But you better document that. I would love to be on body cam, but you better document that. You have to, whatever this notice is, you better be able to prove it to a court that you gave this person notice. That is individualized notice. Unfortunately, putting a sticker on a car is not individualized notice because there is no evidence that he has actually received the notice, right? Do I agree with this decision? Not really, but I'm also not a due process expert. I am a search and seizure expert, so this is a little outside my wheelhouse about their connections to some Supreme Court cases and so forth. But it is the law in the Ninth Circuit. All right, so that's what I think about it. That's some feedback for you guys. If you're not in the Ninth Circuit, you're probably rolling your eyes and you're thinking to yourself, "This is why they call it the Ninth Circuit." Because of stuff like this. I mean, can they just do anything right there? Right? Does the Ninth Circuit have to just get involved in every single thing that communities do to try to keep their communities, safe and clean and so forth? And the answer is no. The Ninth Circuit wants their hands in everything. So there you go. If you found this interesting and helpful, let me know. Put it in the comments or hit the like button. That really does help the channel. And if you want me to answer your questions, bluetogold.com/show.